Hi, and welcome to our workshop on due process rights for parents who are in jail pre-trial. My name is Deidre Cunningham, and I'm going to allow my co-presenter to introduce himself.
Hi, I'm Richard Pittman. I'm with the Louisiana Public Defender Board in Louisiana. I got interested in this topic and wanted to do something on this topic a couple of years ago when we had a case come out of one of the Louisiana parishes in which a parent was being held on very serious charges in jail, and while still awaiting trial on those very serious charges, had her parental rights terminated without ever having a real opportunity to work a case plan, being in jail the entire time. And that just struck me as fundamentally unfair. And we're going to go through a discussion today about why and what we see as ways to protect your clients who are in jail, specifically when they've been in jail without having been proven guilty of anything. With that, turn it back over to Deidre.
Yeah, hi. So I'll finish introducing myself. I'm the Incarcerated Parents Project Resource Attorney here in Washington State at the Washington Defender Association. We are a nonprofit public defender advocacy and education organization. I used to be a public defender and supervised public defenders who did all sorts of cases, but specifically representing parents and kids in family regulation system courts. I also am interested in this topic, not just because I'm a resource attorney working with incarcerated parents, but because I represented parents and at least one child who had to reinstate his parents' rights after her rights were terminated when she was incarcerated. And it occurred to me that I think what really got me motivated around this topic is that I saw and continue to see quite a few families that shouldn't even be in the court system to begin with, because the parents made good choices for who should be caregiving their kids while they were incarcerated. And yet the department still filed cases, and many of those families had either experienced or are still facing termination of their parental rights or their family relationship. So that's what interested me in this topic. And with that, we are hoping that we can give you just the beginning of some things to consider when representing these parents and their helping them reunify these families. Richard, do you want to advance so we can introduce the ground rules for respectful discussion?
Well, there they are. We don't want to go over them one by one. They're available out in the lobby. You can take a look at them. We just want to remind you that they're there and ask for you to honor them in the chat.
Yes. So the scope of our conversation today, there are many other circumstances which lead parents who happen to be incarcerated, who then end up their families being filed in these child abuse neglect allegation proceedings. Okay, so we wanted to make sure you understood the scope of what we're going to talk about. We are talking about cases where either the only reason the state agency is involved is because the person is confined, and that means they're not available to have custody and provide care to their child, so unavailability, or because the state agency has filed in part or in whole because of the criminal allegation that has led to them being held in jail before criminal trial. So it's narrower than anyone who's ever been incarcerated with a dependency case, but we are hoping that to give you some ideas and some tips around these two types of parents you might encounter. So some of the key topics or takeaways is that we'd like you to think about how to get these cases out of the system before dependency is entered, how to get the parent out of jail, how to meet their needs if they cannot get out of jail, collaborating with the criminal defense attorney, coordinating your client's goals in the child and family case with the goals of the criminal defense case, and then defending against termination of parental rights. Okay, so just to start off, does this state agency, the child welfare agency, need to be involved at all? And I offered up in the files. There's just a very short practice advisory that I actually reconfigured to have mostly SCOTUS cases, because obviously this is a national conference and you all don't need the Washington Supreme Court cases on this topic. But basically the subject matter is protecting the parent's placement. Many times we encounter families and parents who are getting filed on solely because they happen to be in jail, not because there's an allegation that they've made poor parenting decisions. They may have even designated a caregiver that the department then wants to place with after they filed a petition, right? And so we're touch pointing on this topic to bring to light that those are those cases that we as parents attorneys really need to work out of the system as early as possible. Do you want to advance the slide or? Yes. So designating a caregiver until release is a really great way of preventing child welfare intervention. Various statutes and provisions exist in various states. So very generally, a lot of states have power of attorney documents that you can sign to confer caregiving for children. Many also have other consent documents around health and education that can be put in place so that the decisions kids need made by parents can be done by a third party while the parent's incarcerated. And short of that, there are also like guardianships and other legal constructs in your state. So what I'm suggesting people do is maybe assist their clients in figuring out what those are. And if they're not in place before filing, try to get those in place before a dependency due process hearing is held. And when those things are in place, we have to remember parental fitness is presumed. Without the dependency finding, it's presumed that their client's still fit to make these decisions, and the case should really be dismissed, particularly when your client is identified, the parent is identified, an appropriate caregiver that the department likes, or that the court would like if it doesn't have the barriers that the department has. We often know that there are some structural barriers that the department can't agree to, but that the court can approve anyway. And so that is sort of the context of this argument. You want to advance, Richard?
All right. So when you're working with a client who is in jail and you're representing them in what we would call a child in need of care case, other states might call a dependency case or something else, anything you can do that might help the parent get out of jail is going to be extremely helpful. Now, some of you may be in a position where you are also their criminal defense attorney, but you may not be. We're going to talk a little bit about collaborating and coordinating defenses a little bit later. But anything you can do to help the client get out of jail, that might be, helping find someone to post a bond if there's a bond available. Coordinating with that criminal defense attorney, because the services that DCFS offers might be the sort of thing that a judge setting a bond or making a decision on ROR release might feel good about and might want to see the client engaged in. Getting those things straightened out is going to be helpful, because your client really can't get started in any really meaningful way, or at least can't get to the finish line, certainly, while he or she is in jail. It's just not going to work. There are too many barriers and obstacles, and obviously if they're in jail, they're not available. But even just getting close to the end, even working that case plan meaningfully, is going to be very difficult. Not impossible. I'm going to talk about that in a second, but very, very difficult. So we need to work to get the parent out of jail if that is at all possible. And that child welfare involvement might, in just that little small way, might be kind of helpful. Doesn't mean you want to get the child welfare involved, but there might be a way to kind of get a silver lining out of that.
Yes. So this slide is just to highlight some of the things that Richard just said, but to get to tease them out just a little bit more. Clients can better help prepare their defense when they're released, and if you've done this work or criminal defense work, you know that that's true in both cases. It's a lot easier to help a client either investigate or mitigate, whatever the case is, when they're not in the jail. In particular, if the client is only being contacted by the child welfare agency because they are in jail, then getting out, being able to set up arrangements, even if it turns out they will go to trial and maybe have to serve some time, they'll be able to set those arrangements for their children that will be long lasting and hopefully more stable, so that this agency won't get back involved just because they're incarcerated. The other thing that I think Richard just said pretty eloquently, but I'll just repeat, is that if they are being engaged in for other reasons, or because the criminal allegations suggest they might have issues with caring for children, then they can engage in those evaluations and services that will demonstrate that they don't need child welfare involvement, or that will narrow what kind of involvement is really necessary. And it might even help get rid of their criminal case or mitigate punishment in their criminal case. So those are things that are reasons why we all know release is important, because no one should be in the jail, but these are additional ways in which release is really going to further help the clients reach their goals.
Okay, so let's say the parent is going to stay in jail at least for some time, perhaps until the criminal case is resolved, or maybe even beyond. What can the parent do in jail with help? And I want to emphasize that, with help, because there's almost nothing they can do in the jail without help. But they can do a lot of things in the jail that will be helpful for their dependency case in the jail with help. And that help can be, this is supposed to represent a caseworker working hard, doing reasonable efforts, and getting your client in the jail what he or she needs. Or it can be the attorney working hard, trying to get the client what he or she needs in the jail. And what that might be, the first and maybe the most important is getting visitation with their kids. And I specifically use the visitation language and not the family time language that I know people are going for, because there's nothing like family time in the jails. And I think the jails would call it a visit. And most jails have a visitation policy for children, where children can come and see the people who are in the jails. As Deidre pointed out for me in one of our planning sessions, many of these jails are housing state prisoners, where they kind of have to have a more liberal and accessible visitation. So they might even have better facilities for that sort of thing. If the jails are resistant to having children in them, then I think the attorney is obligated really to force the issue, to make sure that is happening, either by bringing it to the sheriff, to the warden, bringing it to court, and I'll talk about motions in just a minute. But I don't think you can just take no from the jail for an answer, or no from the agency for an answer, like, no, we're not taking that child to the jail. Well, I don't think you can just accept that. Visitation, it can be considered the most important service in a child welfare case, and just discontinuing that because the child is in jail, I don't think is justified. Like, yes, I don't think that seeing the parent in jail is necessarily the best way to see the parent, but I think it's better than not seeing the parent. It's perhaps less traumatizing than not seeing the parent. And keeping the people, the parent and the child, engaged in the process through that visitation is ultimately going to be very helpful in the case, particularly if that person has been in jail for a while, or is going to be in jail for a while. And finally, make sure somebody's bringing that child there, and somebody's with that child. Don't rely on it to work out, or don't assume there's an understanding. Make it very explicit who is bringing that child to the jail and when.
Yeah, and just if I could just say one more thing about visits, Richard, for folks to think about is, obviously this is developmentally dependent, right? So teenagers are going to need different arrangements from toddlers, and that does matter. And so when you are forcing the issue, really consider that younger children need contact visits. And I would suggest pushing harder, because if you ask for contact visits and they say no, you might get more video, more telephone calls, more other types of visits. If you never ask for the thing that's really developmentally appropriate, you might end up with even less. And so the Jails often do have face-to-face places, and some jails actually do have, like Richard was suggesting, some places do actually have appropriate visiting spaces. And so because it's a national conference, I have no idea what your local jails have, but you want to investigate that first. Don't just assume that it's like the photo, even though a lot of places are like the photo. Some places do have visiting rooms, or have a space that's just as nice as the agency office visiting space. So that's all I wanted to add, Richard, thanks.
And something else you can do is just when the case is coming to court, make sure your client is transported from the jail, make sure the child is going to be there, and you can have a little visitation at the courthouse. Again, better than nothing.
Yeah, for sure.
Another thing that can happen in the jail, you've probably seen this in criminal cases, mental health assessments or services can be conducted at the jail or can be done on like an outpatient basis. Some places will transport under certain circumstances to that. And if they won't, see if you can get it ordered. It depends on what the arguments are going to be about that. People will go into the jail to provide services to people there to help them. Right. Drug assessment and treatment is also provided in jails on a fairly regular basis. These things are not. It's not an excuse that someone's in jail to just cut them out of the case. And I think a lot of caseworkers will just want to cut somebody out of the case because they're in jail. And I don't think you can accept that. I think you need to fight for them on that basis because they need the most. But there are going to be barriers to doing it. Don't accept the lame excuses like we can't get our person in the jail or people don't want to go to the jail. Well, he's in jail, so he can't have the child anyway, so what's the point? Children aren't allowed in the jail. There are all sorts of things that jails are not hermetically sealed. People get in and out of them all the time. Service workers get in and out of them all the time. Attorneys go in and out of them all the time. They are not sealed off. Things can happen within them. And so what can you do about it if there is resistance to providing any sort of support within the jail? Well, I think the thing to do is to file a motion. First you try to negotiate it. Whoever your obstacle is, you try to negotiate with them. If it's the caseworker, you try to negotiate with them or their supervisor. If it's the jail itself that doesn't want to provide any benefit, you can negotiate with the sheriff or with the warden or whomever. And if nothing is going to happen, I think you need to file a motion. That can be a motion for visitation, a motion to compel services, a motion to compel the sheriff to allow the inmate to participate in your family team meeting or your court or whatever by phone or by video conference, whatever is available. There's no reason that the jail has to be someone in jail has to be entirely cut off from society and entirely cut off from their family and entirely cut off from the things that are there to visit, that are there for them. And finally, a motion for no reasonable efforts finding. The jail is not an excuse from the reasonable efforts requirements that are in the law. You look through Title 4E and ASFA and the other things where these requirements are found. You will not find in jail as an exception to a requirement to do reasonable efforts. There are all sorts of aggravating factors you may find in your state law, but just simply sitting in jail, even with an indeterminate end time, is not one of them.
Right. And if I could offer up too, just on a couple of these ideas, one of the things that if you've done criminal defense work, you probably know this about the jail, and if you haven't, which is fine that you haven't, your local PD's office might be a resource to you. So there are almost always face-to-face spaces in the jail. The police use them. Other folks, when they take DNA from folks, they use them. When they do neuropsychological or psychological evaluations for criminal cases, they're in a face-to-face space. There are rooms that are used for those professional visits. And so when we're talking about compelling services, that's where those professionals would go. to either do an assessment or provide those services, and that can usually be arranged. And so if you're not familiar with your local jail policies, the PD office probably knows the fastest way, the person to really email, the person to really call, and how to set that up. And so I would say use them as a resource. The other thing to know about some of these suggestions is that the people who might, and I'm looking at a little bit of the chat and saying this, the folks who might be most resistant to setting up services or keeping the client engaged are the folks that have the duty to do that. So social workers might not be familiar with these rules or with these policies, and they might also need to be encouraged to have these meetings. And if you're concerned about what's the social worker going to say to my client, you could set up a face-to-face with you and the social worker and your client and be doing some case planning. So those are just a couple additional ideas, and I certainly will turn it back over to you, Richard. I didn't.
Please jump in whenever you think you have something relevant to say.
No worries.
I don't like monologues. I wish we had more of an interactive system, but I understand the limitations when we have 1,000 people at this conference. And you may have heard this. Our position is that she is in jail by choice. She did what she did to get in jail, and for those of you who were here for the opening plenary by Professor Guggenheim, and you saw how wound up he gets about the injustices he sees in the child welfare system. This is when you need to do that. You need to just take the biggest offense you can take to somebody saying something, whether this is in court or in a meeting, and you need to say, no, she's not in jail by choice. She's been put there by the state, by your colleagues in the state, and she is presumed innocent. She has not been found guilty. She has not admitted guilt. She has not done anything. This is what you went to law school to learn how to do. Is to stand up when injustice, when you see it, and to yell and scream about it until everyone just finally says, just stop. Yes, we agree with you. Just let's go on with this. Like this is one of those situations where you have to sometimes pick your battles of when you're going to get as animated as you want to get, and when they say our position is that she is in jail by choice when she hasn't been found guilty of anything, is one of those times. It's one of those times when it's time to stand up on the table and put a show for your client, and just get as mad as your legal training trained you to do. Do we understand that? Do we have agreement on that position? Like it's wrong, it's unjust, it's incompatible with our constitutional system of accusing people of crimes, and you can't just sit there and say like, well, actually, she's presumed innocent until proven guilty. No, you got to get up there and get their attention and get mad and make them uncomfortable. And that's where. Go ahead.
I was going to say also, don't be afraid to also say, like, people, especially when they haven't been convicted, they're not in jail because they've done something. They're in jail because they can't pay to get out, right? Mm-hmm. So there's another layer of injustice. I mean, there's two layers of injustice. They're not only presumed innocent, but they're also just too poor to get out. So if they had money and they were accused of the same exact thing, they wouldn't be in jail. Do you understand what I'm saying? So anyway, I think I agree with Richard. Just
you want to make them never say that again.
Yeah, exactly. Raging is the right way to go on that.
This is where we decided to stop and take some of the questions that were in the
ask for questions. And so I'm going to check to see. There are a couple in here. Richard Gould has in a question. How can you allow a criminal defendant to engage in services when any service will require they acknowledge what the reason behind their involvement in the system is? Would that not cause problems with the rights to remain silent? It's a great question. We have a couple
of slides about that.
We have a couple of slides about that, but so we could hold and come back to that question when we go over that piece. But very generally, I would say we're going to get into collaborating with the criminal defense attorney, and this is a good prompt for that. Because the first thing as the child welfare attorney you need to know is that true, right? is it true that the service that's actually being requested would implicate their Fifth Amendment rights? So if we could just ask for hold on a little bit of that so we can talk a little bit more about a couple of our other points today. I think it's a great question. Another question we have, though, is have you run into issues with services in the jails due to COVID? We in Washington State had a really different experience, I would say, when we first started quarantine about a year ago, because we had more cases than most folks were dealing with in March of 2020. And for a moment, things just completely stopped, I think, so that folks could figure out what to do and how to get a handle on it. But we almost immediately, our child welfare, our parents' attorneys started litigating. We should still be having in-person visits and services should still be able to be provided. And our service providers started doing virtual provision of services, some of them. So I think one of the issues that folks have experienced has been just making sure that logistically that the access points could be access to virtual services if those were taking place, and continued access to the visitation that was being provided would take place. Although most of that was virtual during the height of spread and outbreak and the beginning of the pandemic. I think that our prison just reopened in-person visitation, but they excluded people under the age of 16. So we are still dealing with virtual visitations in the prisons, but as other institutions like jails open up, I think we're going to start seeing people relitigate, hey, we need our visitation back. We need to start the visitation in the jails again. I hope that answered your question.
Yeah, and again, just don't forget they're there because of poverty. Like that's one of the reasons they're stuck there in jail. I do like this question from Christina Lewis. Any tips on advocating for visitation with a parent who is being held in a jail far away from the child's location? Tough. Yeah. I think if maybe you can help arrange transportation of the child. But again, I think the motions need to be there. Like I think a little distance shouldn't be a huge obstacle from a legal standpoint. Now, if they're in another state or if it's really a haul, like I really don't have much of anything. But if it's like an hour away, I don't think that should be considered a big obstacle. Pietro?
Yeah, I agree with what Richard just said. What is a far distance can be relative. Being in a state as large as Washington State, I can tell you that there's about 2 strategies that we employ. Firstly, getting on paper what the actual distance is. So we've had situations where people in the same county, it can take 4 hours to get somewhere. And we've also had situations where that will get you from Seattle to Spokane, right? So it really matters, what is the distance, what is the timeline, how old is the child? But the thing I also suggest, so challenge the representation, just some conclusory representation, it's too far. Because too far might be from downtown Seattle to Bellevue, which is a suburb. And yes, it might take 90 minutes, but it's still it's like, less than 10 miles away. So we need to really make sure the court understands what they're asking and what they're saying. But the second part of that is to layer context. So if someone is only getting that in-person visit every, you're asking for them to get in-person visits only, then it's going to be harder when those don't happen. So you want to have more regular phone calls, layer that with video calls, layer that with letters and notes and cards happening on a regular basis, and then have maybe a visit once a month or a visit every 6 weeks that's in person. So that drive, let's say it really is a 4-hour drive for a 4-year-old, which is a lot to ask. That's happening once a month maybe, or once every 6 weeks, but they're getting video calls, they're getting the phone calls. And so it's not just every 6 weeks they're seeing a parent, if that makes sense what I'm saying. So the second strategy is to layer context so that when it is really far, you're still doing it, you're just not doing it as often. And it's a multitude of ways that the parent and the child are staying connected.
And something about that question just occurred to me. Here in Louisiana, at least, and perhaps elsewhere, sometimes somebody is arrested in their home parish, what you would call a county, and then they're held far away, like on the other side of the state, because the jail is too small or whatever, or there's an exchange of money involved. Well, I think there's another opportunity for advocacy, which is advocacy to bring that person back home. This is someone who should be held, if they're going to be held at all, should be held locally because of the importance of their ties to their family and the importance to the child welfare case that happens. So that's another opportunity for advocacy. I wanted to address very briefly Travis Fink's question, which was actually put in the chat and not in the questions folder. Since when do judges follow constitutional mandates on bail or parents' rights? I understand where you're coming from, but I think we need to fight against defeatism in these cases and a thought that, well, the judges aren't going to be fair to our clients. Because if we really believe that, why are we here? Why are we here if to learn new skills if we think it's hopeless because judges will never listen to them? Like, it may be true that your judge doesn't listen to them. You keep working it. You try it on the next case, and then you try it on the case after that, and you just keep trying, and then maybe finally it starts getting through, and you work on that advocacy, and you start case after case after case. You work on that, and you beat on how important it is to be fair to these clients, and eventually it gets through. I'm not going to say it works every time, but I don't think you can go in with a defeatist attitude that there's nothing I can do that my judge will listen to. Even if there is nothing you can do the judges will listen to, you want to go home at night knowing you did a good job. So try.
So Richard, there's a question we haven't touched on that I want to just quickly say, and I think we'll move to the next section. I believe Sarah Klosterman was just noting that she believes in Ohio their services at their prisons are still halted. One of the things I would suggest, I think, as I said about when we were first litigating quarantine in Washington and the impact on families, just because in general the prison said we're just not letting people in to do regular programming does not mean that you cannot litigate in an individual case that a professional needs to either virtually have connection with this person who's in the jail or prison to provide service, or in person be authorized, screened pursuant to the COVID restrictions so that they can provide those services. And I wouldn't take the conclusory statement for the general conclusory statement by a DOC or jail that we're not doing services as the end of the conversation. That doesn't mean they can't authorize a specific professional to come in a safe way and provide a service. And so I would push back on the details, even if it means that person's going to be on a phone with a glass barrier with your client. Okay, then that's how it's going to be. If they're going to be on video calls on Zoom, maybe that's how it has to be. But I wouldn't give up on that because your timeline's not going to stop in these cases. So that's kind of what I would say around that.
Next.
Yeah. So next slide, working with a criminal defense attorney. Okay, this is the good stuff. So if you are the criminal defense attorney, this is going to be really weird. You're going to have an out-of-body experience. No, you have to work with yourself. No, if you're working as primarily as a family defender and the criminal defense attorney is either not in your office, not you, or maybe in another jurisdiction, we are still suggesting that you really strongly consider raising the importance and the critical nature of your case, the family defense case, to that criminal defense attorney, and with an eye towards collaboration. So we have a picture.
No, the picture didn't come up. Let's try it again.
Oh, there it is. Okay, he's pointing at his own. I think is that his book? Yeah. So the thing we want folks to take from here is that, look, there are, and some of the questions have already touched on this, there are going to be those times, particularly the types of cases where part of the criminal allegation is the reason for the child welfare intervention, right? The state is alleging mom's accused of child abuse, so we want a dependency case. And if you're not collaborating with the person representing mom in that child abuse allegation, then it will almost be impossible for you to serve that client well. So one of the preliminary things I would say is you want to make sure to have a release The criminal defense attorney is going to want a release anyway, because they're not going to talk to you without one, but you're going to want one also because your case also has confidential files and other issues that you don't want the criminal defense attorney running around talking about either. Not that they would, but you want it to be really clear in writing what your boundaries are as defense attorneys. I'm going to turn it over to Richard, but there's one more thing I want to say about that. I think that with regard to that question we already had around services, this is where working with a criminal defense attorney is a helpful tool, because not all services are going to implicate the Fifth Amendment, right? It actually matters what they're asking the client to do. It might, but it might not. And how would you know if you're not really engaging in the criminal case? You don't know if UAs are going to be harmful. You don't know if that drug assessment's going to be harmful. And so it's really important to nail that down, because if it isn't going to be harmful, then of course the client might want to engage in it to demonstrate sobriety and to show they don't have a drug problem, right? And so those delays in your case can be super harmful. So it's really important to get answers, concrete answers about the specifics, and you do that by collaborating with the criminal defense attorney. I'll turn it over to you, Richard.
This picture is meant to represent that criminal defense attorney who has a very, very high opinion of himself and a very, very low opinion of the kind of work you do, because his work is a lot more important than yours. Well, I have news for him. But before I do that, I sent out an inquiry to the listserv about an actual case that came up in the time we were planning this, which I was asking about. That very case where someone was obligated to confess to serious crimes as a prerequisite to getting the therapy services that the case plan required. And someone responded, and I purposely de-identified this quote because I was so bothered by it, I didn't want to call the person out. In state, a parent receives a court of juvenile case and a public defender for any criminal case. Sometimes these two attorneys talk, but more often than not, they don't, and most don't seek each other out. And I don't think this is any way to do these cases. I don't think this is actually, I don't think this satisfies the rules of professional conduct, frankly. ABA model rule of professional conduct, you in all likelihood have something very similar to this in your state. A lawyer shall abide by the client's decisions concerning the objectives of the representation, and as required by Rule 1.4, shall consult with the client as to the means by which they are to be achieved. And I'm sorry, I would have asked for ethics credit if I knew I was going to put this in there, but that's what came in during the planning session. I don't see how you can possibly abide by the client's decisions concerning the objectives of the representation if you have two separate but interrelated cases being worked on independently by two lawyers who aren't talking to each other. How is that client getting good advice about the objectives of the representation? How is the client giving consistent feedback about what their goals are? I think Rule 1.2, and it might take a little bit of reading into it, but I think Rule 1.2 basically makes it imperative on an ethical standpoint that a dependency attorney for a parent and that parent's criminal attorney in that related criminal case need to at least be communicating with each other at some level, just so that they're not working at cross purposes. And we're going to talk about how those cases can overlap in so many ways, and how not working together can be harmful. So, and for your criminal defense attorney who does not think very highly of the kind of work you do, I would ask that person, what do parents fear most? 1 year in prison or never seeing their children again? And I had my first child right after I started working in this system, and I came to understand this very, very well. Actually, my only child, I should say. It is never seeing their children again that they fear the most. That is what would bother me by far the most if I was in this situation. Now, that calculus might change a little bit when you start talking about LWOP or death penalty or something like that. But I had a client charged with capital murder who had death penalty on the table, who every time I talked to her emphasized to me how much her children were important to her. And the fact that she was not going to be able to see, she had not been able to see her children, and any offer that was being given to her to plead out was one that would like get her out of prison at the least when her children were in their 30s and 40s, and how much that bothered her. Even the ones facing extremely serious charges can get preoccupied with their children. And I don't know that all criminal defense attorneys understand that.
And Richard, just to offer up, I think we've all had clients where, very serious charges are filed, a lot of time is on the table, and the criminal defense attorney really believes that their case is the main event. And the client really only wants to know, but am I going to get visits? Even if I take this plea deal, that's going to get me 17 years instead of life or whatever the deal is, right? And I've had a client that was facing 17 years was the good deal, and all she wanted to know is if she was going to get visits, right? And so, to your point, we can't answer that question. That's the client's choice. That's why client-directed goal setting is really important, and also why collaboration is important. Because what ended up happening in my personal experience in cases like that is that how I work for the client in her parents' rep case and her family defense case shifted from getting people who are usually against visits in prison, right? Getting them to have a relationship with the client, getting them on board with having that relationship, and getting people on board with having adult siblings providing visitation, right? Which is a completely different focus from every other case that you might have, right? It might create a case plan for you as the attorney, a defense plan that is a little different than what you're used to working on, but that's the success model, right? That's what the client wants. And so I just want folks to hear that, yes, you challenging the criminal defense attorney is really important, because it also gets you to think about, well, what is the client's goal here? And if that case really is going to be the client's in prison for 17 years, how do I be successful as the parent's attorney? How do I get the client what they really want in my case, right? Even if termination happens, right? Because we all know that then sometimes parents are subject to something more serious. So I just want to, I hope that's helpful. But
and if your client says, I'm really worried about prison, okay, well, that's their call. Like that, they get to decide what the goals are. So you're listed as this one, but I don't know.
Yeah, you can say it. Make noise.
So if you have that criminal defense attorney who is just not interested in taking your call, you need to get your megaphone out, and you need to get that person's attention and make that person hear you and respect you and include you in this process, because you might do something to harm his case unwittingly. We'll talk about that on the next slide. But you need to demand their time and their respect, and have them acknowledge that your case might be just as important to that client as their case. All right, let me try to get that white bar off the screen. There we go. So how can these cases intersect and interact with one another? In all sorts of ways. Like plea bargaining the plea bargaining that goes on in a criminal case might impact your dependency case. Like that plea that the criminal defense attorney is negotiating for your client might harm their dependency case, and they need to know that. Or it might really help their dependency case, in which case they probably need to know that too. Testifying in the dependency or the termination of parental rights case might come back to haunt your client in the criminal case, or refusing to testify might harm their TPR case. Engaging in a services plan might be beneficial in their criminal case. The criminal defense attorney might want to know for bail purposes that your client has arranged drug treatment or mental health treatment or job skills training. That might be very beneficial. The criminal defense attorney would probably need to know that. Seeing counselors, talking and possibly talking about the crimes can have impacts on these cases. And there's discovery in criminal cases and in dependency cases, and they're not necessarily the same thing. So talking from one to another might give both of you information that the other one didn't have. Brady material. DCFS is probably, the department is probably handling Brady material, and your criminal defense attorney might not know that. Things in your file might be very beneficial to the client that in their criminal case, but if you're not communicating with the criminal defense attorney, or if the criminal defense attorney is not communicating with you, that connection might never be made. And mitigation can be important, and the child welfare work can be important for the mitigation. So much of this is dependent. Like, I can't tell you which way things push and pull. So much of it is going to be dependent on like the personalities and the local politics. Your plea bargaining, that plea bargain that gets that client out of jail immediately might be great for your child welfare case, or it might kill your child welfare case. I don't know. That's probably going to depend an awful lot on your DA. It might depend on your agency or your judge. That statement from the department that says, look, if this parent can just get out of jail and have a home, we'll give the child to them. That might actually move a DA to say it's in the interest of justice to dismiss this case. It's in the interest of justice to plead this out to a misdemeanor and get this person out of jail. There are all sorts of ways these things can interact. And you don't want to be siloed, because that's just going to hurt the client.
And just really briefly, because we are going to jump into some strategies around some of the concerns you guys are raising in the questions, but I wanted to say, someone was asking a question, Richard, about the statutes about confidentiality in these cases and family defense cases. And I think what I'm asking folks to do, because we are all in different jurisdictions, one of the things you need to really figure out is, what am I allowed to share with my client? And what am I allowed with release of information to share with their other attorney? Does that affect any kind of privilege? Does that waive the statute? And if you think it does, what's the procedure for protecting that kind of communication? So normally, even if there is confidentiality in collaborating with the criminal defense attorney, it might only apply to the records. Maybe you can speak to them, but you shouldn't be providing file records without a court order or without permission or without some other document, right? So I'm not saying that's the law in your state. I'm saying those are the things to think about. I always say, first, you want to look at your own analysis for speaking with the criminal defense attorney. Normally, a release is required, a written express release under, in our state, it's 1.6. The confidentiality provision for attorney and client, right? It's at least that much. You might need to add to that so that you're protected. But I would suggest proceed slowly before changing records, exchanging records, and sending documents places, because you also want to make sure you're not disclosing things that the prosecutor or the state's attorney can discover later. So I'm saying be cautious. And yes, those are the types of questions you should be asking yourself when setting up the collaboration with the criminal defense attorney. But it doesn't mean that you don't want to do the collaboration. It just means you want to do it the best you can and as correctly as you can to protect the client's rights.
And see, I would take the position that the dependency attorney talking to the criminal attorney is just one person talking to himself. I don't think there needs to be any friction in that whatsoever. But different strokes for different folks.
But you may, so I agree with you. If that's how your state rolls, then knock yourself out. But if you are in a state where they do kind of have these rules, I'm just suggesting there's probably an answer to that question. You feel free to lean on your ethics counselor, your ethics consultants at your state bar if you have questions about what your state laws say. But I'm just suggesting don't give up on the idea of collaborating just because it might be a little bit new or complicated, because it's still worthwhile to the client to make sure they're not prejudicing themselves in either case. Yeah, that was it. Sorry.
Well, and this is the moment you were waiting for.
Yeah.
You can't provide services if she doesn't admit what she did.
Yeah.
Okay,
So
so this is a tough one. Deidre, do you want to start?
sure, I'll start. So again, unfortunately, right, we're working in different fiefdoms that have different rules, but I decided to write out something that hopefully will be helpful to you guys. So basically, there are a few approaches that can be taken when you're dealing with that case where someone is accused of a crime and the basis of the criminal allegation is partly why they want a dependency or all of the reason why they want a dependency case. And so there are a couple layers to this, so bear with me. We wrote a few ideas down, so I'm going to hopefully flesh out just a couple things. Seeking immunity. We're going to have I think we have.
Go to the next slide. It kind of
yeah. Let's go to the next slide.
Right.
Seeking immunity is really interesting. So a lot of states may have a state immunity clause, like a state immunity law for these cases. The issue with immunity is this: people have the right to invoke the Fifth Amendment privilege against self-incrimination anytime, anywhere, in response to questions where their Fifth Amendment right might be implicated, right? So if they're being asked about potential criminal behavior, they should be invoking. So that's sort of the question that the gentleman asked in our last part of the session. Well, how do we move this family case forward if they're invoking? And that's another reason why you have to get really specific with the criminal defense attorney, especially if it's not you, to know, are these questions implicating the Fifth Amendment or not? Okay, so I'm saying that out loud to say this. What's coextensive with the Fifth Amendment is use immunity and derivative use immunity. Transactional immunity would be awesome. That means for this particular behavior, they can never be prosecuted. But most people are not going to get transactional immunity. So we need to do the best we can to try to get them the protection they need in the child welfare proceeding, as close to the Fifth Amendment protection as possible, meaning the statements where they're admitting something criminal are not used at their criminal case later, or evidence that could be derived from that statement is not used in the criminal case later. This is crash course. I'm not expecting you to leave here as an expert in immunity. What I want you to hear is that some states have statutes that provide this protection. Some states have statutes that provide partial protection, and some states have nothing. Other states have case law that does this. So I'm just suggesting that you look into this, because this is something that really does allow, when you do have the ability to get use and derivative use immunity in your state, it allows parents to engage right away once the orders are entered, right? It allows them to move that child welfare case forward. The other thing I wanted to point out is that courts have inherent powers to issue stays of proceedings. Some states have great laws on getting stays of the civil case while the criminal case is pending. I don't know that you want to do that when the person's stuck in jail, but if you can get the client out and then stay the dependency case, by all means, do that, because then they don't have to do discovery and testimony and other sort of services and other things while they're waiting to defend their criminal case. Another idea is to seek out protective orders. So for places that don't provide sufficient immunity, and this really depends on, someone else mentioned, well, our state prosecutors do our juvenile court cases. So this thing I'm about to say probably doesn't help those folks, right? It really works well when the state attorney is not the prosecutor, but I'm gonna say it anyway. So when you seek a protective order, what you're really trying to do is constrain the parties in the civil case from collecting information, knowing things, and then divulging those things to other people. And so in the case that you have, if that makes sense to protect information given to a provider, a service provider, a therapist, if it makes sense to seek a protective order to prevent records from traveling from one place to another, then that's what you might want to do, right? If there's a report you don't want people to read, then maybe nobody gets that report. I have a sample motion. When we seek these protective orders in Washington, we try to get the court to use an evaluation form that has almost no information on it, right? The person was evaluated by a professional and the person either recommended services or didn't recommend services. So it doesn't even say, because we're thinking about in cases there's no immunity granted, right? If the criminal prosecutor decides to admit something related to this person got an evaluation, what does that evaluation actually say, right? And is that evidence that can be used against the client? Anyway, that was a really deep rabbit hole, but basically these ideas that we wrote are strategies for either stopping your civil case from going forward when you can't get it dismissed, and therefore stopping the compulsion of the client having to make statements and answer questions that might implicate their Fifth Amendment privilege, right? Or you set up a scenario where they've got the immunity they need, again, use and derivative use immunity, to engage, and that you've got protective orders in place so the reports are not flying around, so that therapists are not talking to social workers, so that prosecutors are not getting information they shouldn't have from your file. And then I'll let you do the rest of this.
Yeah, a lot of these are just talk to people,
yeah.
Talk to your therapist. Is there a way to get around that? Do you really need this person to admit that they abuse their child in order to help them? And if they do, maybe there's some other therapy and some other service that can be, satisfactory, that doesn't make them do that. Can you reach an agreement with a prosecutor? I have known prosecutors with a degree of humanity in them who would have been like, I don't want to be unfair to this person. I want to give this person a fair shot, particularly if the charges aren't all that serious, like they're not murder or something like that. I want to, let them testify. I won't ever look at the transcript. I'll give you a written agreement that's enforceable, that I can't use it, maybe except for impeachment or something like that. But, there might be ways to negotiate your way out of this. I like the argument, like this Charlene TT case out of an intermediate appellate court in New York said that requiring this for services was not reasonable efforts. It wasn't a reasonable thing to ask someone facing criminal charges to do. And then now this is an intermediate appellate court in New York on a 25-year-old case, but it's something. The other case law, not that great, I'm going to tell you.
But you can make the argument.
You can preemptively argue that look, any confession in this kind of a scenario is inherently coercive, and kind of preemptively kill that confession.
Yeah, and just to double up on what Richard said, you can make the argument though, because maybe your state, your jurisprudence doesn't have a bad case yet. Maybe it just hasn't been litigated, and so with an eye towards creating good law in your state, making that argument. And I really like the last suggestion. Often the barrier to arguing coerced confessions in criminal cases is that the person's not physically incarcerated, but we're talking about folks that are stuck pre-trial in jail. So they are actually incarcerated, and the state is trying to compel them to make statements to state actors, to social workers, to the contract provider. So it's a much better argument for the criminal defense attorney. So don't give up on that argument in this context.
It's novel, but
yeah.
Try it. I may have my client speak in hypotheticals in counseling. I would wonder if your client had that kind of discipline. Okay.
And to that end, if you have, can I just offer up one more thing? We're going to ask for questions, but sometimes we're concerned that our clients can't invoke, or maybe they have, there's a challenge to their neurodivergent and legal, and I'm not even sure, I might be neurodivergent. Legalese doesn't always make sense to me either. And so we're just worried they get into an evaluation and we don't know if they're going to actually invoke at the right moment. We historically in Washington, we had a case, it was a Court of Appeals case that I think is still good law, even though our Supreme Court just ruled on a similar issue, where parents' attorneys got the right to attend. They just did a motion to attend. They had clients with developmental issues. They're like, these folks are not going to be able to help, invoke all by themselves without us being in the room. And so the court said, yeah, you can be present. And I would suggest that you also be thinking about those things. If your client ends up in a situation where they don't have immunity, the case isn't stayed, it's going to move forward. The criminal defense attorney is concerned, you can make a motion to be there. Sorry, to assist.
Okay, let's see if we have any questions we can address. We're running a little short on time. We have to get to our TPR defense. Confidential.
think we have most of the questions covered, except there is a question from Rachel Espeo that I don't
Rachel
think we've talked
Espeo.
about.
Okay.
And advice for handling
cases where the
cases.
overlap between criminal and dependency is child sex abuse allegations. I've had a few over the years, and it's only ever resulted in reunification once.
I have advice.
You know, I don't.
I do have advice. I think the strategy is the same, because the first strategy is always, 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 if the parent is not immediately available, is to find the person that is an agreed upon suitable caregiver and get the case dismissed and out of court. That is always the strategy, and sex cases are no different. So I definitely think the hardest cases are the sole caregiver, the sole primary parent is the one accused of harming the child in the case, and the allegations are sex, and you're not able to get any kind of protective order or immunity pre-trial, and you're waiting for that case to go to a criminal trial. That is the hardest scenario. I have often found, for some reason, folks accused of these sorts of crimes tend to have a network of folks they can lean on. There tends to be family members that might be appropriate, but honestly, it's to me, the first strategy is always divert for anyone, and these sex cases are not different.
Okay, so termination defense. This is where your client is still being held pre-trial. Your time limits have expired. It's gone to termination, and they're relying on the statute to terminate parental rights. Now, your client may be still very close to his kids. This may be a very tragic situation. This is going to be a very tragic situation for your client. But put on your lawyer hat and let's make some legal arguments. I mean, we can sense why this is unfair. Let's put some legal arguments to that sense of unfairness. In the law, parents are presumed fit and defendants are presumed innocent. And the state has rendered your client unfit by accusing them of a crime and sticking them in jail. That is the nature of the dependency that has been alleged. Whether it is that purely for their unavailability or they're being accused of something that is also criminal, like the allegations of dependency are also criminal in nature. We've already been over there. They are in there voluntarily. That is bullshit. That is an constitutional argument, and we can't abide by that. So what does our Supreme Court say about this? A finding of parental unfitness is constitutionally required. I would argue that when the state has made your client unfit by its actions, that doesn't fly. That doesn't work for that finding. And parental unfitness cannot be presumed based on the categorical status of a parent. Here, that categorical status is they're confined in jail. I don't think that can make the client unfit ipso facto. Deidre, did you want to expand on that?
Yeah, so this is, I can't elaborate on what you just said, but I can say that when you're dealing with folks equating the mere fact of incarceration with parental behavior, what we often get stuck in is this idea that they can't physically have custody and therefore intervention is needed, intrusion is needed. And I think we need to remember to broaden our mindset. I know it's in the materials around protecting parental placements, but I have quite a bit of law in there around this is a bundle of rights. And some of those rights include the right to make the decision where your child's living while you're not available. It's making the choice, the autonomy, right? It's the personal autonomy that's being interfered with for the parent of making all of the choices relating to the family life, or all of the choices related to child rearing. Okay. And so we also, when we're thinking about unfitness, we need to think about that more broadly and educate the court that it is not merely the fact that they're incarcerated, is this broader thing. And that is where I think it's easier to see that unfitness is not really been proven, that the state is not going to be able to meet its burden, that they aren't able to make good decisions, that they've somehow made a decision by not having the money to post bail. I mean, you see how it kind of falls apart when you try to equate what are the parents' actual actions to this notion of unfitness. as it relates to their ability to make decisions for their kids. And so it was a really long-winded way of saying, don't let them say the category that all people who are confined are presumptively unfit parents, because again, pretrial detention is about inability to pay and being accused, not about being convicted and having some adverse finding against you.
Okay, you can make a narrow tailoring. Oh, sorry, that's Deidre.
Yeah, so this is like, the reason I put this in there is there are termination statutes. I mean, I did a cursory search. There are quite a few state termination statutes that try to call out incarceration alone in some way as a basis for grounds for termination. Now, often they don't actually do that. They either say it's prohibited or they say it's incarceration plus, because why? Because substantive due process requires that the state, it prohibits, the state from infringing on your fundamental rights unless there is, it's narrowly tailored and there's a compelling state interest. And so you will find that for some states, they either prohibit the use of incarceration explicitly, or they'll say it's incarceration plus you hurt a child. It's incarceration plus something else, right? Because just incarceration alone by itself probably does not meet this constitutional standard. And so so I just put this in here to remember, if you're in a state that is calling out the status of confinement, think about, there's a difference between being accused and being convicted. If it just says incarceration, it's not differentiating, right? So there's probably a challenge there. If your statute explicitly says you can, terminate because someone's incarcerated and they haven't articulated harm, so that doesn't require incarceration due to child abuse conviction or incarceration due to homicide against a child, right? Like, it's just, this person could be in on a theft charge and they get to terminate because of, like, you got 2 years or something like that. That's not narrowly tailored. I guess what I'm trying to suggest to you guys is that you still may have that substitute due process challenge to make in your case if you're in a state where the language is not narrowly tailored. And so anyway, that's what I meant by that. And you can take the next section if you want.
Every termination statute in the country requires at least clear and convincing evidence for its statutory elements to prove. What we have if someone is in jail is a grand jury has found probable cause. What even is that? It's certainly not clear and convincing evidence. And if it's a grand jury, your client didn't even have an opportunity to confront it. It was done entirely by the DA. That's nothing. That's nothing really. So if you've done criminal cases in addition to your dependency cases, what can happen in a criminal case? They fall apart all the time. Like they fall apart on the eve of trial. A witness disappears, the evidence disappears. The prosecutor finally looks at his file and says, I can't prove this. And the person gets released. Well, if that person gets released, but parental rights have already been terminated, on a case where that the state couldn't prove, it's a grave miscarriage of justice that has been perpetrated upon that client when that has happened. And we need to guard against that. And I'll skip past the picture. We are getting very short of time. This is the Louisiana, part of the Louisiana termination parental rights statute. I put this up only as an example. Ours is particularly harsh. 1 year elapsing from the time when the child was removed from the parent's custody without substantial parental compliance with the case plan for services and no reasonable expectation of significant improvement. Now, if you look at this clinically without an eye towards the humanity of the people involved, you can say, he's in jail. We don't know how long he's going to be in jail. Hasn't really been able to do much of anything while he's been in there. Seems like the elements of this statute are met. Well, let's look a little past that. And let's look at some ideas you can propose for ways that this process can be made more fair to the parent. We can say, well, let's make the TPR wait until the criminal case is concluded, or until the parent has had a meaningful opportunity to work towards reunification, or let's make them release. How about we make them release the parent from jail as part of their reasonable efforts? You know, the reasonable efforts is supposed to be the state as a whole, not just the department. Well, the state as a whole is keeping this person in jail. Or another one is at the TPR trial, ask the court to require the state to prove the underlying offense. You know, and if the underlying offense is complicated or novel, and the very last slide, if we're able to get to it, you know, the case that I was talking about earlier was a case where the mother was accused of murdering her youngest child under a shaken baby syndrome case. Well, that is a complicated and difficult case to prove, and arguably all the forensic on it are bunk. You know, they might never have been able to prove that case, but they went to termination with her still just sitting in jail. Mm-hmm. So we're proposing new procedures. What happens when you propose procedures? Well, there's a case, a classic case from the Supreme Court, the Matthews v. Eldridge case, that talks about procedural due process and what process is fair. And it gives us 3 factors to look at. The first factor is the private interest that will be affected by the official action. The second factor is the risk of the erroneous deprivation of that interest through the current procedures. And the third is the government's interest in preserving the procedures as they are. And I'm going to talk about each one of them one by one. I think you can see where this is going. The private interest that will be affected is enormous. The private interest is the ability of a parent to ever see their child again. And there's all sorts of good case law on this. Lassiter, if the state prevails, it will have worked a unique kind of deprivation. A parent's interest in the accuracy and justice of the decision to terminate his or her parental status is therefore a commanding one. A commanding private interest will be affected. Santosky, the classic, the fundamental liberty interest of the natural parents in the care, custody, and management of their child does not evaporate simply because they have not been model parents or have lost temporary custody. Even when blood relationships are strained, parents retain a vital interest in preventing the irretrievable destruction of their family life. This is a case here from Louisiana. The potential loss in a child welfare case is grievous, perhaps more so than incarceration. You know, you undoubtedly have similarly grandiose language in a case in your state. You surely must. That you can quote when arguing for your increased procedural due process under the Matthews v. Eldridge factors. You know, a commanding interest in the care and custody of their child. The risk of erroneous deprivation. Well, as we talked about, the criminal cases, they just fall apart all the time. Like, sometimes, very surprisingly, they'll just fall apart at the last minute when a witness refuses to testify or something else happens. You know, you hate to say it, but sometimes prosecutors just don't even look at their file until they're prepping it for trial the week before. And they say, my witness doesn't say the right thing. I can't prove this. Yeah. And parents shouldn't lose their fit but accused parent. Deidre?
No, I'm everything you're saying. We have one more factor on Matthews. This obviously, these slides were taking time to say, look, challenge this procedure of trying to terminate when people haven't been convicted and are just being held pretrial. Challenge the procedure as not being comporting to procedural due process. And so the third element, because we're going to hit 2:30 pretty soon, the third element is the government interest in maintaining this current procedure of charging someone with a crime, asking for a bail they can't afford, and then trying to take their child from them either temporarily or permanently. Yeah, and permanently is where we're at right now with the TPR. So we're saying the government's interest in maintaining this procedure, right? It's not legitimate. I mean, you first start with, this is not a legitimate government objective to charge people with a crime, never bring them to trial, and try to terminate their rights in the meantime. They're tainted, the state has tainted the parent's fitness by just accusing the person. They will eventually have to prove their case anyway, so why are you terminating parental rights? You should be forcing the state to bring that criminal charge first, right? If the proof is...
Or even, sorry, Deidre, even prove the allegations in the termination of parental rights case. Prove that the incarceration is justified. You know, if this person really shook her baby to death, show it. They're going to have to do it eventually anyway.
Yeah. If the proof is complicated, expensive, or novel, all the more reason to fear erroneous deprivation and to slow down and be cautious. And so if the state is either saying we shouldn't have to do this now or we can't do it now, then our job as the family defender is to say, then you need to do your criminal case first. We should not be doing the civil case first, right? You know, I don't know that I have more to say. Did you want to, before we go?
I do not. I think that,
okay.
You know, I think it's Matthews v. Eldridge and the three factors. This is U.S. Supreme Court law on procedural due process. I think it's very strongly implicated in these cases where the state has rendered your client unfit to parent by their accusation, which has never been tested in court. And just think about how paltry the protections are for someone accused of a crime. There's really no way for them to get out of it unless there's technical problems with the charging instrument until it goes to actual trial. There's just no way out. There's no way to force your way out.
Yeah. And Richard, I know we don't have a lot of time and there are questions, but one of the questions that someone asked was sort of, can we litigate Miranda in the criminal case when the case is, you know, the person's been interrogated by the state social worker or by the state contract provider and things like that. I think just to back this out a little bit more, I feel like having talked to Richard in the planning sessions and seeing your questions here today, there's a lot of states out here where the prosecutor is the one prosecuting your dependency case. And so in those situations where there's a lot of crossover between the state's prosecutor and the criminal case in your case, these arguments are stronger. Okay, so the need for protection for the client is higher because there isn't even the facade that they wouldn't be collecting information to prosecute your client with, that the social workers are actually here to rehabilitate. They're not. They're agents trying to get dirt on your client. Okay, so these arguments are actually stronger when those state attorneys are the same people or in the same office. I just wanted to say that before we concluded because we didn't get to address that. But I think even these procedures that we just talked about, is this procedural due process? This argument's stronger when it's the prosecutor who is doing your dependency case because they're the ones setting up the entire procedure that your client is being subjected to.
I wish there was a way to mark a question as having been answered so that I could sort through it.
I know.
Mr. Reagan, that's your feedback from your presenters for future updates to this software. We need to be able to mark a question as having been answered.
Yeah.
Okay.
But we might have reached our time.
I think we reached our time. You can sit here and read this if you want. This is more or less a summary of the case that got me interested in this. I'm not going to claim it's right in every detail. It's kind of my memory of the case. De-identified, of course, but this is basically what we were looking at. We were looking at a woman accused of murder under a shaken baby theory, where she denied this ever happened. She was an immigrant with very limited English skills. She was isolated and depressed. It was a really terrible situation. She and her partner both denied being involved in it. I'm sorry to say it did not have a happy ending. But you know, we put together a lot of arguments for her. In the files is this PowerPoint, PDF version of this PowerPoint, a draft of an amicus brief that I ended up drafting but didn't end up using, that contains a lot of this Matthews v. Eldridge analysis, and also some equal protection analysis on the basis of poverty for someone who can't get out of jail just because they're poor. You are welcome to use it. You are welcome to quote from it. I don't need you to credit me. I just need you to say nice things about me. And if it works, let me know. I would love to hear that any of this stuff works.
Absolutely. Absolutely.
Mm-hmm. And with
With that, our closing slide has our contact info. So maybe go to the closing slide, Richard, so folks can see. The PDF of the PowerPoint is actually in the files here. I think you can come and get those things. And feel free to email. I know Richard just said you can let him know if you're successful with his materials. Please email me or come to the Washington Defender Association website. I have other materials. I have some materials that are Washington specific, but they're at least framed on how to think about issues around immunity and protective orders and stays, and some other ideas around services when someone is criminally charged and trying to get their child back, trying to reunify. So feel free to email me. There are a couple questions I think I saw in the chat that we didn't see because it was in the chat list. So if you want to send those questions, I'm happy to send you my ideas via the email. And it's been great to talk with you guys and great to co-present with you, Richard. It's been fun planning this session.
It has been. I enjoyed doing this. I hope you all enjoyed it. Thank you for coming and thank you for staying. We're 6 minutes over time. I apologize. But, you know, I hope it was worthwhile.
Yeah, for sure.
There hasn't been anything added to the chat in like